I'm ready to get started. Thank you so much for that introduction. And hi, everybody. It's me again, Shanna Welsh-Levin, your Southern California real estate attorney with Southern California Real Estate Law. And I want to thank any of you who have voted in the San Diego's Best in the Union Tribune poll for voting us Best of San Diego. And also, if you're enjoying our blog on LinkedIn or Facebook, please make sure to like and share that as you see it. So today's discussion is about the California Eviction Moratorium. It's an update on the status because this has been going on. We've been doing these webinars since April, and we finally have some breakthroughs, some good and some bad. There's a lot of news about COVID-related eviction moratoria and new legislation that we feel that landlords really need to know about right now for the last quarter of 2020 and going into 2021. And we want to prepare you to move forward and break out of this COVID cocoon and arise like a new beautiful butterfly with a full understanding of where we're going from here, and hopefully seeing the light at the end of the tunnel and seeing good things in what lies ahead, because I think it's going to be a long and difficult road, but we're here to see you through all of this. We're going to go through the Judicial Council emergency rules. There are some changes to those happening as of September 1st. The next steps and new challenges as we see those rules being withdrawn. I will review pending legislation, trying not to get too granular. It's a little bit complicated. And then we'll just review the local eviction moratoria updates. Many of those are expiring soon or have been extended. And then at the end, live Q&A. So the end of the emergency rules of court, rules 1 and 2. These rules in particular have been in effect since April 6th and have prevented us from obtaining a summons in our eviction cases. We've filed a bunch of eviction cases, but the courts have not been allowed to issue the summons. And now we're on the threshold of obtaining those summonses and being able to move these cases forward as of midnight, September 1st, 2020. So it's just those 2 emergency rules that are going to sunset. You can look more in depth at the California Judicial Council website. They have a newsroom, and you can see a couple of the articles that they've published, particularly statements by the Chief Justice of the Judicial Council about how they're going to move forward and the decision that they've made. So meanwhile, the Judicial Council and the legislative bodies, the state of California, have worked together on planning this. While they are allowing these or withdrawing these 2 rules, the legislature is working hard to pass a couple of pieces of legislation that will effectively continue the moratorium to a certain degree. So our next steps and challenges with the court. First and foremost, and we're focusing primarily here on the withdrawal of rules 1 and 2. We're going to save the issues with pending legislation next because the pending legislation is not for sure. Although the courts in San Diego County are open, we believe the next hurdle, once we are able to get those summonses, will be the fact that the courts don't appear to be holding any live trials. And especially in the unlawful detainer division, the courts seem very uncomfortable with the idea of holding virtual trials. There are some virtual trials going on, but in the civil unlawful detainer department, to our knowledge, there haven't been any. So even in those cases where a judge has determined that there's a public health and safety reason to issue the summons and allow the case to go forward, we're not aware of any of those cases actually going to trial yet, even the public health and safety ones, even the ones with those kinds of problems. We don't know if they're moving forward. So without trials, many of these evictions are still on hold. The courts seem to be very uncomfortable with the virtual trials because many tenants tend to represent themselves in court, as well as many tenants being indigent and requiring the ability to access legal aid and access an attorney for their representation. Virtual trials are extremely difficult, and this is why the court has trepidation. I've had one evidentiary hearing so far. That was yesterday. And I prepared as much as I could. I had training with Court Call to learn how to use their software. And for me, it went smoothly, but I still had questions all along the way. Even the morning when I was logging in, I was asking the Court Call moderator, you know, when should I upload my exhibits? How should I present these? How are you seeing people present them? So to think that a self-represented tenant or an indigent tenant who's only met their attorney for the first time would be able to have a fair trial, I can understand why the courts are so concerned about this. So in the Unlawful Detainer Department, Department 60, you can go on the court's website and they have a rundown of their virtual trial procedure, including the software that you have to download and how to use it, instructions on how to use it. But again, we don't believe they're actually using it for trials as of yet. So on a higher note, what we are going to be able to do, once we have the summonses, we will be able to serve the lawsuits on the tenants. As of yet, we've been able to file the lawsuit, get a case number, but we can't serve the tenants with the lawsuit. Once we're able to serve the tenants with the lawsuit, then we wait and see if the tenant is going to file an answer to the lawsuit, or are they going to ignore the lawsuit and take a default, meaning that we get to default them. So if we take a default, we can still get a judgment without a trial. A default judgment doesn't require any kind of appearance by the tenant, or really, it usually doesn't require any kind of personal appearance whatsoever. So with the summons, depending on the tenant's reaction to the lawsuit, we still may be able to move many of our cases forward to judgment if the tenant chooses to be defaulted. The other possibility that will arise once we get to actually serve the lawsuit is tenants who respond can negotiate with us. And a compromise often is found where the tenant agrees to a specific move-out date, and in exchange, the landlord agrees to possibly write off the past due rent, allow the case to remain sealed, meaning that it wouldn't show up on the tenant's record, it wouldn't show up in public records, it wouldn't show up on their credit. And we put this agreement in writing. Tenants can also agree to leave the property in good condition, remove all of their personal belongings. Sometimes there's a cash for keys agreement in these stipulations. We put this in writing. We can enter the stipulation with the court. The stipulation may or may not say that the court may issue the judgment immediately, not to be enforced until the day after the date that the tenant agreed to move out. And so this allows us not only to get the move out date, enter it with the court, but we can also schedule the lockout. And in exchange for the tenant's agreement, all of these other benefits go in their favor, such as not having the eviction on their record and possibly not having to worry about the past due rent. I calculate that at least 2/3 of the cases, the eviction cases that we handle, do result in either a default judgment or a stipulated judgment. So even if the court won't conduct trials at this time, we still feel that we'll be able to complete at least 1/2 to 2/3 of our cases. Another really recent development that is very positive for landlords is that the sheriff is conducting lockouts. In some of our previous webinars, I mentioned that we performed an eviction back in February. Judgment was entered late February or early March, and the lockout was actually scheduled with the sheriff. The sheriff was going to go to the property and perform the lockout procedure on March 17th. Of course, that's a pivotal date because that was when the courts shut down. And at the same time that the courts shut down, the sheriff shut down its lockouts. The tenants have been sitting in that property, not paying rent, having been evicted until this week. So just yesterday, I believe, I actually have to check in and make sure it happened, but I believe the sheriff went out there and performed the lockout for that property on August 26th. So the tenants really lucked out on that one. But the good news is that the lockouts are moving forward, which means that as far as the county is concerned, their eviction moratorium has also ended. Okay, so moving on to the pending legislation. This is a particularly difficult piece for me because this legislation is relatively new, and I've been trying to not get too lost in it while it's been working its way through the legislature, because there have been a lot of different bills. There's been probably 10 different bills proposed, and now we're down to about 2 that have a very good chance of passing in the very near future, those being AB 1436 and SB 1410. We're still watching AB 828 and SB 939, but those 2 appear to have stalled. And then we have Prop 15, which is not a landlord-tenant issue, but it will affect landlords. So I may mention that one in passing. So in part because of the proposal to sunset the emergency rules, the state legislature has been working on these pieces of legislation. SB 1410 is the proposal to add Civil Code Section 1947.20 relating to COVID-19 emergency and tenancies. And then AB 1436 is the Homeowner Tenant and Small Landlord Relief Act of 2020. And if you want to pull the full text of these bills, you can go to http://leginfo.legislature.ca.gov. And maybe Becca might put that in the chat so that you could look these up yourself. So AB 1436 particularly applies to residential tenancies. It addresses concerns of widespread evictions and foreclosures by providing up to 12 months of temporary relief to financially distressed tenants, homeowners, and small landlords. It states that some interesting facts are set forth in the beginning of the legislation. It states that when the Judicial Council emergency rules are withdrawn, in the County of Los Angeles alone, 120,000 households, including 184,000 children, will face the imminent likelihood of eviction from their homes. It also addresses concerns for small landlords who are at risk of foreclosure on their investment properties in their homes. Around 17% of California households who own their homes subject to a mortgage told the United States Census Bureau's Household Pulse Survey for the week of July 16th to July 21st that they have only slight or no confidence in their ability to pay the mortgage in August. 17%, that's a lot. While temporary forbearance is available to homeowners with federally backed mortgages pursuant to the CARES Act, some other lenders have also voluntarily agreed to provide borrowers with additional time to pay. Not all mortgages are covered by any kind of mandatory forbearance. A wave of evictions and foreclosures would force some individuals and families to move in together, often in overcrowded housing conditions that promote the spread of the virus. Many other Californians who would likely become homeless. In addition to becoming a humanitarian calamity, such an outcome would likely facilitate further spread of COVID-19. I'm reading directly from the statute because I think it's poignant and it explains why this legislation has become so important to our state. So they believe, public health officials believe that COVID-19 spreads most rapidly through close human-to-human proximity. Public health officials have therefore emphasized the importance of physical distancing, access to good sanitation, the role of good personal hygiene, particularly hand washing, and self-quarantine for those exposed to the illness as key components to fighting the spread of COVID-19. All of these things are rendered more difficult, if not impossible, by homelessness and residential overcrowding. So that is key to what is happening in the legislature. With regard to AB 1436, what it proposes to do is, number one, there's a lot of language at the beginning about mobile home tenancies. I'm going to gloss over the mobile home part because I don't think there are a lot of issues. Our office is not seeing a lot of calls relating to mobile homes, a few. If you want more information about mobile home tenancies, I would be happy to offer that to you. maybe in a separate call. So you can put that in the chat, or you could email me separately if you want more information on the mobile home part of it. The second part is about mortgage forbearance. The proposal in the legislation is to require mortgage forbearance by lenders if the homeowner provides a certain declaration to the lender. And then it would require the lender to forbear, and there's a lot of detail as to how that procedure would work. If it passes, it will provide a significant amount of relief to small landlords and homeowners. The third part, which is more relevant to landlords, is an amendment to California Code of Civil Procedure, Section 1161. For those of us who are familiar with doing 3-day notices, all of the 3-day notices fall under CCP 1161. The amendments are to CCP 1161 Sections 2 and 3. Section 2 is where you have a 3-day notice for non-payment of rent. When a 3-day notice for non-payment of rent is issued, it's issued under 1161 Section 3. It also applies to Section 2. It also applies to Section 3, which is the part that allows you to give a 3-day notice for illegally subleasing the premises if the tenant is not allowed to sublease. Again, this is for residential only. The amendments in particular, it's just a paragraph that's added to each of those sections, which states, I had it right here a second ago. There it is. An unlawful detainer action under this paragraph shall be subject to the COVID-19 Tenant Relief Act of 2020 if the default in the payment of rent is based upon COVID-19 rental debt. So in the same legislation is a little bit further down, the COVID-19 Tenant Relief Act of 2020, and I will review that with you momentarily. So that statement is added into those two sections of 1161. Then the COVID-19 Tenant Relief Act has a few different features. It provides for a tenant to provide a written attestation of COVID financial distress. If a tenant provides this written attestation of COVID financial distress, then the tenant shall be able to forbear the rent during the covered period of time, which is basically March 4th through 90 days after the end of the state of emergency, or April 1st, 2021, whichever is earlier. So if the tenant provides this attestation to the landlord, then the tenant can forbear the rent for that duration of time and has the time to repay that rent, which is defined as COVID-19 rental debt, for up to 12 months. There's a lot more detail in there, and I'm still absorbing exactly how it works. So step by step, it's really hard to read the statute and then write out how it's going to work. So I'm still kind of absorbing that. But so what you could understand from this is that tenant provides a written attestation of their financial hardship related to COVID. The landlord accepts that. The landlord doesn't have to accept it, they receive it. And then that COVID-related rental debt has up to 12 months to be repaid. And they're predicting that this will all be over by April 1st, 2021. I hope so. And this applies only to residential tenancies. So that is the AB 1436 in a nutshell. Like I said, there's a lot more detail to that and a lot more to absorb in order to fully understand the impact that it's going to have on residential tenancies if it passes. But I also want to point out it has not passed yet. The most recent changes were made on August 14th. The bill is still in committee. It has not gone to vote on the floor, but we do expect that to happen probably by the end of this month. Then we have SB 1410. It's called the COVID-19 Emergency on Tenancies. The bill provides a plan for tenant tax deferment, tenant rent deferment, and certain tax incentives to landlords. So the proposed law provides specific language for an agreement that is meant to be offered by the landlord to the tenant when the tenant has not paid some or all rent during the state of emergency. So the state of emergency in the statute is not fully defined yet. State of emergency is written currently in the statute as March 4th, 2020, and until blank, literally ___ days after the state of emergency has ended. So we don't yet know how far reaching this particular piece of legislation will go. So for an unknown period of time after the state of emergency has ended, if the tenant has not paid some or all of the rent during that period of time, then the landlord may offer this written agreement to the tenant. If the landlord and the tenant enter into an agreement, the landlord may receive a credit against their tax liability pursuant to several new revenue and tax codes that are written in the statute. So the law, if passed as it is currently drafted, would also add another statute, Civil Code Section 1161.05. This would invalidate all notices of termination of tenancy, including but not limited to 3-day notices under 1161, and generally every notice of termination served during the state of emergency and up to an unknown period of time thereafter. So it's that same period of time from March 4th, 2020 through X days after the state of emergency is lifted. And I just noticed that there's a discrepancy. I was saying that CCP 1161, but it's Civil Code 1161 when I was talking about the earlier statute. So we're talking about Civil Code Section 1161.05 would be added, and it would invalidate all of the 3-day notices, and it's not limited to just those 3-day notices. So if this passes, what our office will be doing is preparing the necessary forms that are defined under the statute. So one of those forms is this rental agreement. The statute actually provides the form of the rental agreement that the landlord has to offer to the tenant, must offer to the tenant. The Franchise Tax Board is also tasked with drafting their form. There is a second form, which is the proof that the landlord has given or has offered the tenant the agreement. And if the tenant rejects it, then the landlord has to attest under penalty of perjury that the tenant has not agreed to this agreement, which is the rent deferment agreement. And then if the agreement is entered into, or even if it isn't, the landlord may apply for some tax incentives. So what we recommend is that all landlords who have non-paying tenants should contact a CPA or a tax attorney to consider the advantages of offering the tenant owner COVID eviction relief agreement to the tenants, and then filing the appropriate form with the Franchise Tax Board as well. It's not written as optional. If the statute passes, this is something that must be offered to the tenants. My interpretation of what this means is I suspect that it would be a nominal amount of relief to the landlord, not really any penalty to the landlord for failing to follow through with this procedure. But the landlord who is trying to sue a tenant for rent would not be able to do so for the COVID-related non-payment of rent. So they won't get anything out of the pursuit of the unpaid rent. And so it's better than nothing. Getting this tax incentive is probably better than getting nothing at all, because it's unlikely that they would be able to collect. The advantage depends a great deal on the amount of the rent that the landlord is losing, as well as their annual tax liability. And this is why we recommend reviewing this option with a tax professional. Concerned advocates indicate that these bills would completely destroy investment properties. I'm quoting from a friend's Facebook post. They would completely destroy investment properties. our firm, SoCal Realty Law, we're not going to pass any judgment on what this legislation would mean at this time, because it hasn't passed and because we don't know what the final format of the legislation would be if it does pass. Both of these bills, including SB 1410, are still in committee. 1410 was most recently amended on August 5th. And so once these pass, we'll do another webinar and do a more thorough analysis of these. We highly recommend that you reach out to your California Senate and Assembly members regarding both of these bills. We do not want them to pass. This would make our lives, from SoCal Realty Law's perspective, much more difficult. However, you know, we are still very sympathetic to what people are going through. But from a landlord perspective, these are harmful. These are going to make all of our lives much more difficult. So reach out to your California Senate and Assembly members. If SB 1410 passes, it seems that all of the work that our office has done for landlords between March through the end of March to date, and then once it passes, we'll still have some difficulty through the end of the state of emergency plus X number of days. All of this work that we've done will be null, and we'll have to start all over after the X number of days after the state of emergency time period is completed. The principal authors of the legislation, the SB 1410, are Senator Tony Atkins and Senator Hertzberg. Some other legislation I mentioned before, the AB 828 and SB 939, we were tracking them. I'm just kind of waiting to see if they start moving again. Let's see, 828 is still pending and seems to have had some activity in July, but 939 was that Commercial Tenant Relief Act, and it has not had any activity since May. Prop 15 was raised in an event that I was at yesterday, because Prop 15 proposes to increase the property tax assessments for commercial properties that are zoned non-agricultural. It's unclear whether multi-family properties of more than 4 units are included in this bill, but it would make the property tax assessment based on property value instead of the value of the last sale. And for the most part, that would increase the property taxes on these commercial landlords. That would trickle down to the tenants, creating more problems for commercial tenants. And we just think everybody's under enough stress that we don't need to, well, I guess my personal commentary is that I think landlords are under enough pressure and tenants are also under enough pressure that we don't need to be doing this right now. So moving on, local eviction moratoria. City of San Diego has extended theirs through December 30th, 2020, but it may still be subject to a, the governor might veto this because the vote was only 5-4. If it had been 6-3, then it would have passed without the possibility of veto. To my knowledge, I think that potential veto is still pending. I couldn't find any updates on that. Many of the eviction moratoria are extended only through August 31st. So that's Chula Vista and National City. So they will probably expire because there was nothing on the websites indicating that they were proposing to extend it. The County of San Diego appears to have already expired. I looked on the county's website and didn't see anything beyond the end of July. Plus, the sheriff has started doing lockouts, which also indicates that the county's moratorium has ended. So the Los Angeles eviction moratorium and the San Francisco eviction moratorium are going strong and expected to continue for an extended period beyond when the state would have them expire. The City of Los Angeles eviction moratorium prevents non-payment of rent evictions for COVID-related evictions, COVID-related non-payment of rent evictions, no-fault evictions, unauthorized occupancy evictions, meaning people who are subleasing without authorization from the landlord, and until the local state of emergency is done. We don't have any idea when the Los Angeles local state of emergency will be will be done. San Francisco, I believe, is extended at least through the end of the year. So the city of Los Angeles also prevents any rent increases, but that prevention only applies to areas that are subject to their rent stabilization ordinance. And the city provides a form and requires landlords to give the form to tenants. The form is, so the landlords were supposed to give the form to the tenants before May 26th. The form is for the tenant to use to notify their landlord of their inability to pay rent due to COVID-19. That means that the landlord has to give the tenants a form and say, hey, do you have a hardship? You know, fill this out and give it back to me. The County of LA has an eviction moratorium through September 30th. It prohibits evictions solely for non-payment of rent due to COVID-19 related reason and no fault reasons under the county code. COVID-19 related violations due to unauthorized occupants, pets, or nuisance. So those are the reasons why the County of LA will prevent you from evicting a tenant. Non-payment of rent for COVID related reason, no fault evictions, and evictions related to unauthorized occupancy, pets, or nuisance. It also prohibits rent increases for rent stabilized rental units in the unincorporated Los Angeles area, prohibits imposing new pass-throughs or charging late fees, interest, and any related charges for unpaid rent during the moratorium period. The tenant must notify the landlord within 7 days after the rent is due of a COVID-related hardship. This moratorium in LA County applies to residential, commercial, and mobile homes. So the good news is that the court will begin issuing the summonses. We'll be able to start moving cases forward, trying to work with tenants to prevent evictions, work with landlords to, not be stuck in court at the end of all of this. And the other good news, since I have a little bit of extra time, is, another discussion in this networking event I was in yesterday was the haves versus the have-nots. And I'd like to separate my time. In business, I work with the haves, and in some of my spare time, I work with the have-nots and try to prevent homelessness. My nonprofit Amicus has had some luck. We found that the environment these days is very favorable toward trying to prevent homelessness and trying to help the homeless. A lot of the homeless people in downtown are now housed in the convention center, and because they've been able to keep a lot of people in the same place, they've been able to really increase the services and improve the services that are being provided to them. And that's a huge development because, that system of helping the homeless is improving because of COVID. Another great thing that happened is the city of El Cajon passed an ordinance. They've changed their zoning code to allow my nonprofit Amicus to use our emergency sleeping shelters as dwellings under certain circumstances. It's been 4.5 years since we built the first emergency sleeping cabin and started advocating for these sleeping cabins as dwellings for homeless women and children. And now, thanks to the city of El Cajon's cooperation, we have a zoning ordinance that allows us to put 6 cabins on a location at a church in El Cajon, and we will have up to 2 years to have a program where people get to live in the cabins. And we hope that that'll be extended because we hope that the program is very successful. So that's some great news. Hopefully there are more developments to come, and I'll keep you guys posted. So ready to take some questions. If you guys want to talk off the record, then I'm happy to talk in private if you're not comfortable talking in front of everyone here today.